Good morning. Every Sunday, we invite the people who make news to discuss the future of the community. Our first guest this morning has been a key player in the corridors of power for over a quarter of a century. From 1970 until 1992, Guy Guckenberger served in the Cincinnati City Council. During that time, he established himself as the spokesperson for environmentalism and an independent thinker willing to challenge the Republican Party line on occasion. In February 1992, Mr. Guckenberger traded the often contentious confines of council chambers for the supposed relative tranquility of the Hamilton County Commission. Ironically, within 3 years, the County Commission found itself embroiled in controversy over the proposed sales tax increase to build 2 new professional sports facilities. And now it's the County Commission and Mr. Guckenberger who will make what is being called the most important planning decision of the next half century. When Guy Guckenberger becomes a judge on the municipal court bench in a few weeks, he will necessarily become much more circumspect about expressing his opinions on the issues of public debate in the community. Before he clams up, Mr. Guckenberger has agreed to join us this morning to talk about his years as a councilman and as a commissioner and to discuss the issues he still faces. Welcome. Glad to have you here. You know, I think for a lot of people, it seems like City Council, County Commission must be about the same thing. What's your experience? Are those 2 very different situations?
They are very different. The County Commission is much more relaxed, much less contentious. I think it's much less bureaucratic than the city. I've really enjoyed the time that I've spent with the County Commission. It's the way you think government ought to operate. Very easy, very informal, and but getting things done.
There are some people and organizations that have talked for years about reforming county government. On the simplest level, rationalizing and bringing certain positions like the coroner and the engineer, making them non-elective, appointed positions so the commission has more control, giving the commission more control over budgets, over certain autonomous agencies that we've seen some controversy with. How do you feel about those kinds of proposals for the county?
Well, keep in mind, we do have control over all the budgets. We don't have control on a day-to-day budgeting process for the mental health organization, for example. But for most of the county departments, we do have budget control. In a perfect world, you would probably reorganize county government because it's an ancient form of government. It's amazing how well it works, though. I have just been really amazed. The problem is, in terms of reform, that the general public is not real interested in reform in terms of just the organizational structure. They want good government. General public wants honesty and integrity in government, but the form of the organization is difficult to work with sometimes, but because of that, almost, it's working pretty well because we all make an effort to make it work.
You've made a couple comments about county government, very positive comments, and after all those years at City Council, could City government learn some things from county government?
Oh, yeah, I think so.
For example?
Well, I think the city is top-heavy in terms of bureaucracy. There's a massive system of managers and supervisors and just a lot of bureaucracy at the city. The way the City Council operates, they almost always have to have a written report in response to a motion. I just think that's, and they've recognized it's a waste of time many times. You know, they could simplify the whole process.
There's been a lot of discussion on another level about cooperation between city and county, and you know, sometimes that's contentious, sometimes, and of course in the little clip that we had coming in to this, part of it was a piece from a debate between you and Tom Luken.
Oh, yeah.
I guess the question I'm heading towards is, are relations between county commission and city government dependent on who the people are and the personalities, or is it a structural question? And what I think of with Tom Luken, a very contentious personality, whether he's on council or off, you know, he's always looking. But I have the impression that, for example, you and Bob Bettinghouse can work pretty closely with Roxanne Qualls. Is it a personality question or is it a structural question?
Well, I think it's a little bit of both. Structurally, we each have our own budgets, we each have our own organizations. We're responsible to our respective constituencies. Technically, my constituency is the same in the city as the city council's is, although I have obviously have people outside the city of Cincinnati. But you're responsible for different organizations, and you tend to want to protect that turf, if you will, and make sure that you do the right thing in terms of your governmental functions that you're responsible for. Then I think it's a question of personalities. It's clearly a question of personality. If people want to talk, if they want to try to be cooperative, it will work. Otherwise, you're just going to fight all the time.
Well, probably the cooperative issue that is before everybody right now is the question of the future of sports facilities, the riverfront. It can be framed different ways. Where are we on that question right now? Let me break it down. How close are we to a decision on where to put the Bengals Stadium?
Very close. And that's why I'm staying on the county commission right now. As soon as that decision is made, I will move to the municipal court bench. We are very close to making that decision.
Are we within days?
Oh, yes.
Okay.
Very definitely, we're within days. It's very likely to be this week. And it's just a question of 500 feet one way or another. Okay. I mean, literally, it's...
Well, what about the Reds Stadium, though?
Let me finish the Bengals.
Okay.
2 seconds.
Right.
Basically, what we're trying to do with the Bengals location is make sure that the city, the Bengals, adjoining property owners are all involved in the process, and we can just kind of tie it up and say, yes, this is what everybody seems comfortable with. The Reds, however, are, my guess is 6 months to a year away from any decision on location. We do not have with the Reds a memorandum of understanding. We're in negotiations with the Reds. Those negotiations are progressing, albeit slowly, I think. And we're in no position, I don't think the county commission is in a position to make a formal commitment to a site for the Reds until the county knows whether the Reds are ready to sign on the dotted line. Because you don't build a house for somebody unless they're going to live in it.
What does that do to this process of planning that you've undertaken with UDA, the Pittsburgh-based planners and ZHA? Does that mean if the Reds aren't willing to make a commitment yet, does that mean these three choices remain up in the air for 6 months to a year? Or will there be a decision about this is our preferred master plan concept?
Well, I think a couple of things are going to happen. UDA has basically given us a list of options, and those will remain constant throughout this process. So whether we make a decision now or 6 months from now, it's 6 to 1/2 dozen the other, I guess, literally. But we'll be able to use that information later. What you're going to see is we're going to pick a site on the riverfront for the Bengals. Then we have issues that we need to decide. Can you fit a baseball stadium someplace in between the existing stadium and the Coliseum? Do you want to do anything with the Coliseum in terms of removing it? And the conventional wisdom at this point is no, you don't want to remove it, because even though it may not be that expensive to buy, you can't replace it for less than $100 million, and that's just too big of an expense for the community. So, you don't want to do anything that's going to affect the Coliseum. Probably not going to see any development between the existing stadium and the Bengals Stadium. Bengals would, of course, be west of the existing stadium. You're not going to see any development in between there because the city wants to keep that open for riverfront access type issues.
What about Broadway Commons? Is it in play?
Oh, very much so. I think it's very much in play. It is a strong possibility. It may be an issue that literally works itself out, because if you want the Reds to stay in town, I'm not just talking about a long-term basis. We certainly want them to stay in town on a long-term basis. But if you build, you rehab Riverfront Stadium, or for example, Synergy Field, then they're going to have to, and they cannot play in the Bengals Stadium because that gets too expensive, too cumbersome. They're going to be playing out of town for a couple of years. Well, you don't want that, because the Reds actually draw the biggest attendance. So if that's the case, and you're not going to build anything between the existing stadium and the Bengals facility, and you're not going to take the property that the Coliseum is on, and you have difficulties putting a new baseball park between the Synergy Field and the Coliseum, well, what do you have left? You have Broadway Commons is an option. So it begins to look as, your question was, is it a player? Yes, it's a very serious player.
But you're not going to be around to influence that decision.
I won't be here to influence that decision.
Okay.
So for all those who want Broadway Commons, don't get too excited. It'll be somebody else.
The bottom line on all of this is Bengals will be decided, and everything else will stay fairly flexible for the foreseeable future.
Right.
Okay. When you move on, do you have influence about who takes your seat?
No.
Do you have feelings?
Not at all. Well, of course I have feelings. Very strong feelings. But
who would you like to see there?
I would like to see my administrative aide, Diane Goldsmith, in this seat, mainly because she knows the business inside and out, and we wouldn't miss a beat in terms of continuity. But it is a decision that is up to the Republican Party by law. The Republican Party Central Committee makes the ultimate decision. They have a lot of different issues to consider and concerns to address, and I think in their infinite wisdom they will make a decision that's good for the community.
We're almost out of time, less than just a few seconds, but why do you want to be judge?
Well, you know, I've been a legislator for 27 years. I've been a lawyer for just about that amount of time. I've been half one, half the other. This gives me an opportunity to do things that I really like in one job for the first time in my career.
Well, have fun, good luck, and gee, I hope at least privately we still get your wisdom if the judges never speak out on things like stadiums, but good luck.
Thank you very much.
Okay. After the break, stay tuned when I will be joined by Dave Mann and Mike Allen to discuss the implication of last week's decision that Judge Lee Hillenbrand violated Judicial Code of Conduct in last fall's election. Welcome back. Usually campaigns for judicial seats attract very little attention. In fact, they are usually so bland that many people enter the voting booth with no clear idea of why they should choose between one candidate and another. Last November, however, a television commercial and a radio commercial run by Republican incumbent State Appeals Court Judge Lee Hillenbrand against Democratic challenger Dave Mann took a very different tone. This week, a panel of 5 judges ruled that those commercials violated the Judicial Code of Ethics by communicating false information, knowingly misrepresenting certain facts, and failing to maintain the dignity appropriate to the judicial office. They fined Judge Hillenbrand $15,000 and instructed him to pay almost $8,000 to cover Mann's legal expenses. The commission also suspended Hillenbrand for 6 months without pay, but immediately converted that to 6 months probation and instructed him to apologize to Mr. Mann and the voters by February 9th. To discuss this development and the implications of this decision, we are joined this morning by David Mann, who is the former candidate for a Court of Appeals, and Mike Allen, the executive director of the Hamilton County Republican Party. We invited Judge Hillenbrand to appear himself, but he did not return our calls. Welcome to Newsmakers.
Morning.
David, given what's happened since the election, this decision this past week, are you satisfied?
I'm satisfied that the 5 judges appointed by the Chief Justice of the Supreme Court have taken a strong stand against lies in judicial campaigns. This is going to have, I believe, a very strong effect on future judicial campaigns. And like all campaigns, judicial campaigns in recent years have increasingly become very uncomfortable, have really dealt in matters that have nothing to do with the question who's qualified to be on the bench. And as this 5-judge panel has determined, Judge Hillenbrand violated the Code of Judicial Conduct. $15,000, a public apology, a 6 months probation, suspension from office. These are major sanctions, and the good thing is that this will really, I believe, result in much finer, cleaner, proper judicial campaigns in the future. So I'm very pleased that the panel has, I think, taken an important step, and I'm grateful I had the opportunity to play some part in that.
Mike, is Judge Hillenbrand going to accept this, or is there going to be an appeal?
I don't know. That's up to him, and he's weighing his options on this matter. From my perspective, I'm disappointed that the panel did what they did. I think it's going to have a chilling effect on the First Amendment rights of people running for judge. The fact of the matter is, in spite of what the judges ruled, that ad, excuse me, that ad was an accurate ad, and we stand by it.
Well, there's actually two ads in question. Most of the attention has gone to the TV ad, but there was also a radio ad that was found to be improper as well. I think we're beyond, we've had 8 judges now rule that those ads were improper.
Well, actually 5 judges and 3.
Well, the panel
others.
before, but just at the time of the election. I think we're beyond that. One of the questions that David just raised was this long-lasting impact on newsmakers right before the election, as I remember, the Sunday before the election. You said, you were here with Tim Burke, and we were talking about this particular case. And you said that you thought once the rules had been changed, in effect, by this ad, that the dam had been broken and that all judicial races were going to be different for the future than they had in the past. Do you agree with David? Now, you put it in terms of chilling effect, but do you agree that we're going to go back to what traditionally has been the way judicial races have been run?
Well, I think there probably will be a change, but I think it's a dangerous change too, though, Dan, because if you're in a race and you're not permitted to talk about your opponent's record, I think that's doing a disservice to the voters. You have to do that in an accurate and fair manner, and I think we did it in this case. You know, Dave, before he decided to run for judge, was a legislator, both in city council and in Congress. He didn't have a record as a judge, as Judge Hillenbrand did. I think it's fair game, I think it's appropriate, and I think it's right to be able to talk about that record, and I think this decision is going to have a chilling effect on that.
Dave, you've run in different kinds of races. Running in a judicial race is different, and should it be different?
Of course. First of all, the First Amendment does not give anyone a license to lie, and as you point out, we've had at least 8 different people, 5 of whom were judges, 3 of whom were attorneys participating in a formal body appointed by the Supreme Court, determined that Judge Hillenbrand lied about my voting record. He did, and as you indicate, that's established and we should get beyond there. What we should be interested in is the qualifications of someone from the bench. And if you start picking apart decisions that were made in the past, for instance, Judge Hillenbrand voted as a member of the appellate court to reverse the conviction of Marvin Warner. Now, I could have run an ad, I guess, under Mike's theory, which I think would have violated the judicial code, that would have said, Judge Hillenbrand, he voted to acquit to reverse the conviction of Marvin Warner. Do you want him to be a judge? Now, that is unfair to Judge Hillenbrand, because the question is, what were the facts and what was the law in the Marvin Warner case? And of course, I would be taking advantage of the presumed lack of sympathy for Marvin Warner to pick on Judge Hillenbrand. I'm sure he would have filed a complaint very quickly if I had run an ad saying that. I never thought of doing that, but that would be the model the other way, or any other criminal conviction that he had voted to reverse, and he did reverse some. Why do you want a judicial campaign to focus on cases when neither the public nor the opponent was sitting there weighing the record and deciding whether an error had been made or not? I think that leads judicial campaigns in exactly the wrong direction.
You know, one of the problems, though, with judicial campaigns, and Mike, you've been a judge, so you know this, from the voter's perspective, it can be very frustrating because it's hard to know, because the code of conduct says you don't run those kinds of ads, Dave, that you just said.
Correct.
And therefore, it's hard for the voter to distinguish between people who are running. Should we even have elected judges? Should we go the direction that some people propose and that a number of states have gone in, which is that judges are appointed by the governor with the recommendations of a panel of lawyers and judges, and get away from trying to, and take it out of this realm of electoral politics on television?
I don't think so. I think the voters should have a choice on who's the judge. And the thing about it is, Dan, if you're going to have elections for judges like we have in the state of Ohio, you're going to have or should have campaigns in elections that are an open forum and an open exchange of ideas. And
But no, wait a minute though. The code of conduct has been there for a long time. That's why judicial races have always been different. So, I mean, you're not saying that we should throw out the traditional code of conduct for judges.
Absolutely not, but you should not restrict a candidate or a judge, a candidate for judge or a judge from legitimate comment on their opponent's record.
Would David's example of bringing up the Marvin Warner case have been a legitimate campaign commercial in your mind?
Sure it would, if it were accurate, and sometimes, nobody likes negative ads. I don't like them, but sometimes they're necessary, sometimes they're effective. David himself in some of his campaigns has run negative ads. He had to apologize for an ad that he ran when he ran for Congress.
But that's a different race. That's not for judge.
Right.
And as a reporter, I know that for years, you ask judicial candidates questions, they'll say, certain questions, they'll say, I just can't comment on that because I'm not allowed. What you're saying is you want to keep the code of conduct in place, but you are saying you want to run a whole new kind of campaign for judges.
I want it to be appropriate, and I want it to be acceptable, and I want it to be not unethical, to be able to talk about your opponent's record. What is wrong with that? Don't you think that the voters deserve that?
Well, and I think that's the problem with the voters trying to make a judgment in judicial cases. I think we've got a really difficult situation here that it goes way beyond just this commercial or this decision.
But let us not lose sight of the fact, if those are going to be the rules, so be it. But those are not the rules today. Even if those were the rules, that would not permit a candidate to do what Judge Hillenbrand did, which is to lie about an opponent. That's what's wrong with what he did. The other thing you need to think about, though, if you're going to start picking apart the past decisions that a judge has made, in the process you're making a logical leap. You're saying, therefore, this judge, the next time somebody like Marvin Warner appeals to him, will have a conviction reversed. Well, that may or may not be the case. Who knows until you have the particular case, the facts, and determine whether errors of law or interpretation of the facts have been made. What the judicial code says is that judicial candidates should not indicate ahead of time how they're going to rule on cases, because there's no way to know until Dan Hurley comes to court what the facts are in Dan Hurley's case. And if I say, I don't care what the facts are, if someone is charged with a particular kind of crime, they're going to be always convicted or always acquitted, then we've lost what the judicial system is all about, reasoned, dispassionate consideration of the facts that are presented in the particular case.
Mike, one of the things I think that is frustrating from the voter's perspective, and I have to admit from the reporter's perspective, is that it's very difficult, especially in an appeals court situation, to even get to the candidate. Judge Hillenbrand is not out on the trail. And since this, he's impossible to get to. There are many gatekeepers down at the Court of Appeals. I've camped out down there. When is he going to come forward by February 9th to address these issues, or?
Well, the interesting thing is, and this shows, I think, the haste within which the opinion was drafted, he's got 20 days to appeal the decision. However, they're asking for the apology by February the 9th. I don't think they did their math properly. I think it was a hastily written and not well thought out decision.
February 9th is the day that his new term begins, so it's a very logical
date.
Well,
I disagree with that, but at any rate, he is not commenting upon this. I'm assuming on the advice of counsel, and when he decides what he's going to do, I'm sure he'll make that announcement. That's his call.
One thing I'd like to point out, February 9th is next Sunday, and we will certainly make newsmakers available to him. I'm being very serious. If he would like to be here to talk about this himself, either with David or by himself. So, yeah, I can't get a message through to him, but if you would communicate that, we'll be glad to make newsmakers available.
That's his call.
Okay. David, you've been through a bunch of races. Where do you stand now? Are you into law practice forever?
You bet. I'm busy practicing law. I love law. I've been a practicing attorney for 29 years, and obviously my law practice was put on the side burner for 2 years when I was in Congress, and last year I spent a lot of time campaigning for judge, and I love the law. I love practicing, and I also have a beautiful young granddaughter that I have some time to spend with. So those are my two priorities right now.
Can you imagine yourself running again?
Well, you never say never. I've been blessed with the opportunity to serve 20 years as an elected official in this community. It's an opportunity that every citizen should have, and I feel nothing but gratitude for the opportunity, nothing but satisfaction at the career, and we'll have to see what the future brings.
Well, thanks to both of you
Thank you.
for being
you.
with us this morning. And thank you for joining us. Be sure to join us next Sunday for 12 Newsmakers.